Every divorce is different. So you cannot take a cookie cutter approach when listing a divorcing couple's property. That's the first thing that you need to know. And when you're dealing with divorces, you're going to encounter several different scenarios. The first is that the couple knows they're going to get a divorce and they just want to resolve as many issues as possible before they actually file. And that might include selling real estate. So, in a situation like that, that's going to be pretty much like your typical listing. They're in agreement, they want to sell. There may be issues that come up, just like with any other real estate listing. So that's scenario number one. Scenario number two is that they have filed for divorce recently, but the process really hasn't started moving along. Maybe one of them has filed, the other one hasn't even been served yet, or the other one has been served but hasn't filed an answer. Those are critical things that you need to know. And one of the reasons that that is so important is because there is something called a standing order. That's what it's called in Georgia. In your state, it might be called a pendente light or something else. But essentially, what that standing order says is that no property can be disposed of without order from the court, nor can the property be encumbered. That means can't get a mortgage on it without order and approval of the court. So, in a situation like that, it's going to be a little bit more complicated to get the property sold. And you might want to just kind of pump the brakes on listing it until the process has moved a little bit further along. And I'm not going to get into all of that today. The next scenario that you might encounter is that the divorce has been filed, the answer has been filed, the parties are moving through the process, and there is a separation agreement in place. That separation agreement basically sets forth the parties' rights and obligations as they're moving through the divorce process. You want to review that separation agreement, if there is one, to see if it addresses the disposition of any real estate that the parties might own. If it does, then you have got to follow whatever is in that separation agreement in listing and selling the property. If it does not, then you really can't do much of anything because of that standing order. The final scenario that you may encounter, and this is really the ideal situation, is when the divorce has been finalized. There is an order in place and there is a settlement agreement in place or a final judgment and decree in place. And what's the difference? If there is a settlement agreement in place, that means that the parties have come together, negotiated, and settled all of their issues, including the disposition of any real estate. If there is no settlement agreement, but there is an order or a final judgment and decree, that is because the parties were unable to agree on all of their issues, and the court had to make the judgment. Either they had a judge trial or a jury trial, and that's how the issues were decided. But either way, you are going to look at the document that sets forth how the real estate is to be disposed of, as well as all their other issues, but all of that stuff really doesn't matter. And it's just really important that you carefully review that settlement agreement and the provisions addressing real estate, okay, or the final order or final judgment and decree. You want to make sure you understand completely what has been agreed upon and ordered by the court. Okay. Now, what you need to know, especially when it comes to the settlement agreement, and it really could be true of the order, because usually it's not the judges writing the order, it is the one of the attorneys writing the order, but that's a story for another day. But you will come across settlement agreements that are just expertly drafted. And you will come across some that are not expertly crafted. They're trash, okay? And like with anything else, you have really good attorneys and you have some really bad attorneys. So, just to give you an example of a situation that I saw during a closing that I did involving a divorced couple, the settlement agreement said that the husband would get to keep a particular property, and that's all it said. It didn't address the disposition of the mortgage. It didn't address when the wife would convey title to the husband. Those are all really important things. But that's just an example of a settlement agreement that was not very well written at all. So today, I have the portions of a settlement agreement from a listing that I took at the end of 2023. The closing finally happened, I think, in February of this year. And I just want to go over it with you and kind of point out why understanding the settlement agreement or the final order, final judgment and decree is so important, and how it really can impact your ability as a real estate agent to effectively list and sell the property, and how when an agreement isn't very well crafted, it can make your life a lot more difficult. So, keep in mind that you want to see the settlement agreement before you ever take the listing. You want to make sure that you understand what you're getting yourself involved in. So, in this agreement, and just to give you a little bit of the backstory, the divorce was final in like maybe February of 2023. Okay, keep that in mind. And there was a lot of animosity between the wife and the husband. They were living in the same house, not the house that is the subject of this video, but they were still living under the same roof. So, just a lot of tension and discord. So, let's take a look at the real property provisions of the agreement. The parties currently, or at the time of my taking this listing and throughout the divorce, were living in a rental property. The property that they purchased early on in their marriage in this document is referred to as the second marital residence. And that property was titled solely in the husband's name, and it was occupied by his aunt. This document says that the parties agree to place the marital residence on the market for sale no later than May 31st, 2023. The parties agree that the aunt shall be allowed to remain in the residence until such time as it is sold. The aunt shall vacate at least 2 weeks prior to closing. Husband shall ensure to the best of his ability that the aunt vacates the home 2 weeks prior to closing. The next paragraph goes on to say what the balance is on the mortgage, that the mortgage is only in the husband's name. To the extent that either party has placed or caused to be placed any further lien, debt, or encumbrance upon the marital residence other than the mortgage referenced above, the party causing such encumbrance shall immediately satisfy same and shall release, indemnify, and hold the other party harmless therefrom. The residence shall be placed on the market for sale no later than April 25th, 2023. The wife shall select the realtor by April 23rd, 2023, and inform the husband of her choice. The parties shall cooperate in the sale of the marital residence. The residence shall be kept in showable condition as determined by the real estate agent. The parties shall execute all documents, perform all acts, and do all things necessary to effectuate the sale of the marital residence. The realtor shall determine the list price of the marital residence. If repairs are needed, they're going to split the cost of the repairs, and the husband will be entitled to claim the mortgage interest deduction on his taxes for 2022 and 2023. And then it just goes on to spell out who's going to pay for what in relation to both the house that needed to be sold and the rental property that the parties were occupying. All right. So I want to just go through and point out some problems and where, in my opinion, it is important for divorce attorneys to have a good real estate agent that they consult with to make sure when they're drafting these provisions of the settlement agreement that they're covering as many of the bases as they possibly can. There is no way to anticipate everything, but in this situation, since the house was being occupied by the aunt, one very, very important question that should have been dealt with was the condition of the property. Neither the husband or the wife had lived in it for however many years. And what I gathered during my initial phone call with the wife was that the house was not in sellable condition. And the reason for that is because there was a hoarding situation going on. So I was kind of prepared for that when I met with the husband to take a look at the house and, see what was up. But boy, oh boy, was it worse than I ever could have imagined. And not only was it a hoarding situation, but there were, I don't know, 5, 6, 7 cats that lived in the house. So, they mostly kept out of sight while I was there, but it just was not a situation where the house could have even been put on the market because of all the crap that was in there and what have you. So, if the attorneys who were drafting this agreement had a better understanding of what real estate agents do. And that's the thing. Most attorneys are not real estate agents, and most real estate agents are not attorneys. I'm kind of in a unique position because I am both, and I can see it from both sides and see a lot of the intricacies and nuances that someone who doesn't sell real estate might not see. Even though they're an attorney, they're smart, well educated, they might not think of these things. So when I put on my realtor attorney hats at the same time, I wouldn't draft an agreement like this where I know that neither of the parties are occupying the home, that this is a home occupied by a family member or a tenant or whatever. You need to know the condition of the property. And in a situation where a third party is occupying the property, I think that the best approach when drafting a settlement agreement would say that the house has to be put on the market X number of days after the occupant has vacated. That way, there are no issues with getting it listed. So in this case, we did not make that May 31st deadline. They didn't even contact me. The wife didn't even contact me until like the first week of May. So that was one thing that was already a problem. They were already running behind. But because the property was, not in condition to be listed, we had to wait, and we waited and we waited and we waited for the aunt to get out, for the home to be cleaned up. And the home had a whole lot of deferred maintenance. And that was something that I couldn't even see the first time that I went to look at it. And once she moved out and I went to look at it again, I saw a lot of things, but there were any number of latent defects that we learned about after the home was inspected once it was under contract. But that's a story for another video. So we missed the May 31st deadline, didn't get the home listed until like the first week of December of 2023. And The agreement says that the realtor shall determine the list price of the marital residence. Well, when I initially spoke with the husband, after the aunt had moved out, we agreed on a list price. Well, and let me even backtrack. Let's talk about the fact that only the husband's name is on title, but the wife gets to choose the real estate agent. My issue with that is that because the husband's name was the only name on title, he kind of felt like he had the final say on everything, including the list price, despite the fact that the agreement says that the real estate agent was to determine the list price. He felt like the wife didn't have a say in any negotiations on the offers that came in. And there was also a certain amount of, I'm going to call it resistance toward me as I was advising them through this process. And ideally, rather than saying that the real estate agent would determine the list price, the best provision is that the wife selects the realtor, and the realtor will recommend a list price, and that each party would obtain an appraisal, and that the list price would be an average of the three numbers, the average of the two appraisals, and then the CMA that the realtor did. That kind of eliminates that feeling that the husband seemed to have, that I was working against him, and he was very, very difficult, and he did not say a lot of stuff to me. He would say it to the wife, and then the wife would tell me. And so I just acted like I didn't know anything that he was saying. But long story short, the best approach is to not put the real estate agent in a situation where one or the other of the parties feels like the realtor is on the other person's side. And so by allowing the wife to select the realtor and allowing the realtor to determine the list price, it automatically kind of put the husband into that state of mind where me and the wife were working against him. And so again, when a divorce attorney is crafting a settlement agreement, they really need to consult with a real estate agent just to make sure that these provisions are actually workable. And did we work through it? Yes, but was it a lot more difficult than it needed to be? Absolutely. So, the other thing that I encountered is that there were repairs that needed to be done, but there were so many repairs, and neither one of the parties was in a financial position to do the repairs. So my recommendation was to sell the house as is. Of course, you understand when you sell a house as is, you're not going to get as much for it as you could if it was well cared for, renovated, upgrades, etc., etc. And so, because the agreement was written the way it was, and really just kind of silent on how the parties would address coming to terms and accepting an offer, the husband was very resistant and very unrealistic. He felt like, why should he accept what he kept calling a lowball offer, and these people, these investors buy the property and renovate it and sell it for, two or $300,000 more, because it was in a very uh, nice area. And when I say nice, it's a transitional area. There's a lot of gentrification going on. Um, but, potentially the house would have sold for, 500, maybe 550 after a complete renovation. And he just didn't want to accept that he's responsible for the 20 years of neglect and the 20 years of deferred maintenance on this house. So nobody should have to pay for that except for him and the wife. And they pay for that by selling it at a lower amount than if it had been well cared for. So, I mean, we had so many offers that he rejected. The wife wanted to accept them because she's like, we just need to get this done. The house isn't worth as much. And he's telling her that I just want him to accept any offer. And she's like, that doesn't even make sense because the more the house sells for, the more money she makes because it's a commission. If it sells for 300,000, she's going to get $9,000. If it sells for 200,000, she gets $6,000. So why in God's name would she want 6 if she knew she could get 9? But again, that was the resistance and his unrealistic view that he should get more because the investor is going to be able to sell the house for more once they pay for all the renovations. Just nuts. But anyway, I digress. So I think that there should have been some mechanism in this document for addressing the sales price, the ultimate sales price that they agreed on. And, it could have been a situation where they put it in writing that if they got any offers that were within X number of dollars of the list price, that they would accept it. Just some vehicle to address this kind of situation. So, yeah, just some examples of, gaps in the settlement agreement that make the real estate agent's life a little bit more difficult. And, every divorce is different, every settlement agreement is different. The skill of the attorneys drafting the settlement agreement will be different. And that's why I say it's so important to see that document before you take the listing so that you know exactly what you're dealing with. So if you haven't already done so, please subscribe to my channel, like this video, and drop any comments. Oh, and don't forget to click that notifications bell so that you're the first to see any new videos that I post. And like I said, if you have any questions, feel free to drop them in the comments. And I am going to share the link to a freebie in the comments as well. And it is just a pre-listing checklist for divorce listings. When you have your very first telephone conversation with someone inquiring about listing a divorced property, go through that checklist and it will help you gather as much of the information as you need before you actually go to the listing appointment.